Hi, I'm James Weaver, and we're here today with another Legal Minute. Today we're going to be talking about appeals from the Juvenile and Domestic Relations Court. So, a judge has just made a final ruling on your child custody, visitation, child support, or protective order matter in the Juvenile Domestic Relations Court, and you're not satisfied with the outcome. Do you have any options? Yes. You have the absolute right to note an appeal of that judge's decision, and you have to do it within 10 days of that decision. If you don't file it within 10 days, you lose your right to appeal altogether. How do I note the appeal? It's very simple. You go to the clerk's office and you let them know that a judge just made a final decision in your case and you'd like to note your appeal. They will process the paperwork, they will send the file over to the circuit court, and you'll essentially wait until the circuit court contacts either you or your attorney. The first thing that the circuit court will do is they will set what's called a docket call. This is a very brief court hearing, and it's not the hearing at which your final trial on your appeal will be heard. It's essentially a court date to set a court date. That second court date is where your appeal will be heard. And this appeal is very important. You will have a different judge, and you will have the opportunity to present any witnesses that you want to bring to court, any evidence that you want to bring to court. And this is true whether or not you brought them to court at the juvenile level or whether you presented that evidence at the juvenile level. The judge at the circuit court level is allowed what's called a de novo review, which is essentially the ability to decide the case any way that they want to, and they are not beholden to whatever the Juvenile Domestic Relations Court judge decided. That includes any evidentiary issues, any witness testimony, and most importantly, any final ruling. One thing that's important to note that if it's a child custody and visitation matter, if there was a guardian ad litem on your case, it's likely that the guardian ad litem will remain on the case at the circuit court level. If you do not file an appeal within that 10 days and the appeal period lapses, the final order becomes unappealable. And you would then be limited to filing what's called a motion to amend in the future, which is what you would need to file if you wanted to change that final order. An appeal gets rid of all those requirements and you get a brand new trial immediately. And if you got a bad decision at the lower court level, this is your best opportunity to get a brand new ruling that is favorable to you. If you have questions about the appeal process or any other matter, give us a call today. Remember, the right attorney makes all the difference.